I think we're going to go ahead and get started. Hi, everyone. Thank you so much for coming to our presentation. My name is Bria, and along with my colleagues Sri and Nick, we are students at the Boston University Startup Law Clinic. We're student attorneys there, and today we're going to be talking about NDA basics: when, why, and how to protect your confidential information. So this is just a disclaimer. This is a general overview of NDAs that we're going to be going through today and the standard practices and things like that. But NDAs are incredibly case and client specific. They're going to be very tailored to you and your situation. So you should speak with an attorney when creating or reviewing one. And if you are here, you're likely eligible for the BU Startup Law Clinic. As long as you are a student at either BU or MIT, you're eligible for the clinic services, and we could help you either draft or review an NDA that you have. So first, we're just going to quickly go over the goals of this presentation. So first, we're going to define a non-disclosure agreement, which is an NDA, determine when an NDA is appropriate, understand the important parts of an NDA to consider as the disclosing party, learn how to review an NDA as the receiving party, and then review what happens if there's a breach of an NDA. So what is an NDA and when do you want to use one? So by definition, an NDA is basically a legally binding contract between two or more parties preventing confidential information from being shared with non-parties. And this is why they're commonly referred to as confidentiality agreements. Basically, you're creating an agreement to keep information confidential. So a key provision of an NDA is creating a standard of care. Now, the parties need to define this standard of care, and this is the standard of care that's going to be taken to protect the confidential information outlined in the NDA. So a standard baseline is reasonable care. However, if you're the disclosing party, which we'll go into a little more later discussing, the disclosing party is the one giving out the information, you're likely going to want a higher standard of care because you want your information to be better protected. So this is something where you can negotiate for something like the best care possible. But if they're receiving party, your obligation will be higher because you're going to be the one having to protect the information. So you're going to probably want something lower. So a good maybe middle ground is to say reasonable care, or at least as much care as you take for your own information, saying that, you know, you need to take care of our information that we're giving you as much as you would take care of your own. But again, this is completely negotiable by the parties, and it will really depend on the type of relationship and the type of information. So what are NDAs typically used to protect? So a big thing is trade secrets. These are things such as formulas, source code, recipes, processes. Like, for example, the Coca-Cola recipe is something that they'd likely protect with an NDA for anybody who knows it. Customer and vendor lists, company business plans, and just generally any valuable proprietary information that has to do with your company, you can use an NDA to protect. So now we're generally going to go over who are the parties, who are the interested people in this NDA. So first you have the disclosing party. And the disclosing party is the party releasing the confidential information. And this is the party that typically makes sure that the NDA is properly written and executed. Because they're the ones that are giving out their own confidential information, they have the best incentive to make sure the NDA is solid and has the best protections for them. The receiving party, on the other hand, is the party trusted with this confidential information. This is the party that's being given the confidential information and has the obligation to protect that confidential information. And then you have subcontractors and service providers. Now, these are parties outside of the main agreement who might gain access to this confidential information, but it's really important to note and think about them when you're drafting your NDA. These can be people such as research firms, data analysts, even a lawyer or an accountant that's going to have access to this confidential information. And while these parties likely aren't going to be signing your particular NDA, it's important to have them obligated to something, whether that is by saying, receiving party, if you're going to be giving out any of this confidential information to any third parties, they need to be subject to something either exactly like this agreement or something similar so that our confidential information is protected. They have the obligation to protect our confidential information as well. So as a recipient, this is something that you might need to consider and again, negotiate or even just list out some of these subcontractors and service providers in your original NDA. And then lastly, you have non-parties, and these are the parties just excluded from receiving any confidential information. These are all the people outside of the relationship that you want to keep this information from. Now, when should you use an NDA? So generally, you want to use an NDA in any situation in which you wish to convey valuable information about your business or idea, but you still want to make sure that the other side can't distribute this information to non-parties. So this is, for example, before speaking with potential business partners or investors in the later stages of your negotiation, where you're ready to get into the nitty-gritty of your venture. This also can pertain to outside consultants and independent contractors and employees, all depending on their level of involvement and whether they're going to have access to this confidential information. So when you're thinking about, when to use an NDA, you should ask yourself, will this person that I'm giving this NDA to have access to the confidential information? And is my information actually valuable? We'll go into this a little more later, but think about whether what you're protecting really needs a solid NDA to be protected. Now, there are situations where an NDA might be inappropriate or just unattainable to get someone to sign. Firstly, preliminary discussions with potential investors and venture capitalists. When you're in these initial discussions, you're likely not talking about, any kind of trade secrets or really getting in depth. And so these people who likely it's their business to invest in companies are probably going to be really hesitant to sign an NDA if you're not a little further along in the process. Any attempt to protect public records, anything that's out in the open already really isn't classified as confidential information. So an NDA really isn't going to cover anything or really help you. And then thirdly, if you create an NDA that has really broad coverage and saying that you really just can't talk about this at all, you might prevent future potential employees from discussing those job details in the future. And that might be a hindrance or even stop someone for wanting to come into your company and work for you because they'll be bound by this NDA. So generally, once you decide you need an NDA, you should determine exactly why you need this NDA. And we'll go into these in a little more detail, but here's some key questions you should consider before drafting or reviewing an NDA. So what are you trying to protect? Who are you giving the NDA to? And how long do you want this protection in place? And these will all determine how you go about reviewing and drafting your NDA.
So now that we have a little bit of an overview of what NDAs do, when to use them and all of that, we want to go through the NDA agreement process with you through a scenario. So think that you have developed a skincare brand. And so you have all new products. And in this situation, some of the things you might be trying to protect might be you have a customer list, you have vendor lists for some of the ingredients that you use, and anything of that such. And then you might have trade secrets such as techniques that you use in creating your products. So you're meeting with a potential investor and you want to share confidential information with them. And you want to utilize the NDA to protect that confidential information from wrongful exposure or theft or misuse by that investor. So as Bria mentioned, you would not use NDA in preliminary discussion. So it's important to keep in mind in this scenario, we are assuming that you have been in discussions with this investor and your relationship with them has escalated and become more serious to a point where you would want to share confidential information with them and you would like them to sign an NDA. So step one will be deciding between a unilateral and a mutual NDA. So as discussed previously, there is a disclosing party and a recipient party. So in a unilateral NDA, one party agrees not to disclose confidential information belonging to the other. So in this case, there is a one-way flow of information from one disclosing party to the receiving party. Versus in a mutual NDA, both parties agree to not reveal the other's confidential information. So in this case, both parties are acting as the disclosing party and the recipient party. So there's a two-way flow of information, and there's an exchange of confidential information. So both parties would have obligations in their roles as the disclosing party and the receiving party. So step 2, we're going to determine who the parties are. So the parties to the agreement are, as Bria slightly touched on, could be the disclosing party and the receiving party, and which the parties to the agreement are usually a straightforward description that's stated at the beginning of the contract. And if it's a unilateral NDA where it's only one side providing the confidential information, then the one side is recognized as the disclosing party and the one receiving is recognized as the receiving party. Versus in a mutual NDA, the parties may also use these same titles of disclosing party and receiving party, but it's recognized and the parties understand that they are acting in both roles as the discloser and the recipient. So one tricky part here is to think about whether any other parties or companies or anyone else might be bound by the agreement that the two parties are signing, the disclosing and the receiving party are signing. So that could be any beneficial or included third parties. That could include related or affiliated companies such as subsidiaries, any partners, agents, employees, service providers. If so, the NDA could also cover those parties. So there's a couple of different ways to do this. So these third parties might need to be recognized in the NDA as that the disclosing party and the receiving party are signing. So you as the skincare brand and the investor. And then the third parties could be included and they could be named and required to sign as part of the NDA, or they might be named and required to sign a separate document with you to agree to keep your information confidential. Another way to do this could also be that these parties may be bound if you as a disclosing party are signing an NDA with the investor. Then the investor in turn has agreements with their employees or partners or agents, et cetera, which binds these third parties to protect your confidential information. So there's a couple different ways to structure it. So in this case with the investor, you may need to find out if there are any third parties that the investor will need to consult regarding your confidential information. And if they are, then if there are any others that would have access to the information you share. So that you prepare for that and decide how to best ensure that these individuals are bound to keep your confidential information protected through some of the different ways that I outlined just now. So step 3 is going to be to determine the purpose of the NDA. So again, it could be initial discussions. Could be it could be used in initial discussions, but again, keep in mind, like Bria and I mentioned earlier, that you have to be careful that it's not too preliminary and the meetings with the investors, it's not too early on in the discussions and they may be hesitant to sign them if it's too early. So that's something to keep in mind with how early you might want to utilize an NDA. And then there's also situations where you might have met with the investor and had these initial discussions, but you did not require an NDA, ask them to sign an NDA at the beginning, but then you've escalated to the point of creating a full relationship with this investor, and you're going to have an agreement outlining that relationship. And so an NDA could be a single section within that larger agreement. So there could just be a section about confidentiality, and it could be incorporated into a larger, fuller agreement that is outlining the scope of the full relationship, rather than one thing to keep in mind is that an NDA does not always have to be a standalone document. So step 4, we're going to want to determine what is considered confidential information. So there's a couple different ways to define it. As you will see, there's some that are more broad and more narrow, and they favor either the disclosing party or the receiving party. So the first one could be all information. So any information that you share with the investor would need to be protected by them as the receiving party, and they would need to keep confidential. It could be only information marked as confidential in writing. So any documents or anything that you send over to this investor, the only thing that they would have the obligation to keep confidential is anything that you clearly mark in writing as confidential. And then it could be any oral information. So this could be information, it would include when you have any, if you set up any meetings with this investor, and anything you discuss, any oral information that flows could be protected. So this is all negotiable. There's some things that each party desires. So the disclosing party will prefer a broad definition so that they could best protect their information and keep the most amount of information that flows to the investor, to the receiving party, confidential. So they might prefer, as you as a disclosing party might prefer all information be confidential, versus the receiving party, the investor, might prefer something like only information marked as confidential in writing, which is more narrow. But there are some problems inherent in something like requiring only information marked as confidential in writing, because this might favor the receiving party, because it will limit the things that the receiving party needs to keep confidential, and it's unlikely to be followed in practice. So if you have communications with this investor over a long period of time, and it involves an exchange of many documents or demonstrations or all these different flow of information that you might have with this investor, it's unlikely, and it will be just more of a burden on you to make sure that everything that you are sharing with them is marked in writing as confidential. So that's something to consider if that's a burden you'd be willing to take on when you're thinking about this negotiating process. And then one thing I haven't talked about yet, which is used a lot in NDAs, that kind of is a balance between all these options, is information that would reasonably be expected to be confidential. So this is somewhat of middle ground that's not too narrow, but also not too broad, so that information that could reasonably be expected to be confidential by the receiving party should be kept confidential. So we can now also move on to step 5, which is determining the exclusions from the confidentiality treatment. So the receiving party negotiates for exclusions from their confidentiality obligations. So these exclusions might address situations where it would be unfair or too burdensome for the receiving party to keep that information confidential. And these exclusions might vary, but we're gonna go through some common exclusions for you. So some exclusions include confidential information that's already known to the receiving party. So if they already possess that information, obviously they are excluded from keeping if you provide that same information to them, they do not have to keep it confidential. It could also, another exclusion is confidential information that's already publicly known. This is something that Bria touched on briefly about if information is already in the public record. It might be unobtainable, like an NDA might be unobtainable or inappropriate, as she mentioned. This is also with the caveat that as long as the recipient didn't wrongfully release the information to the public. Another exclusion is any confidential information independently developed by the receiving party without reference to or use of the confidential information of the disclosing party. So if the investor had developed this information but on their own without using your confidential information, then they'll be excluded from the information. It would be excluded from confidentiality treatment. And the last one is any confidential information that is disclosed to the receiving party by some other party who has no duty of confidentiality to the disclosing party. So in our scenario, if you as the skincare brand shared information with the investor, but the investor has a relationship and you signed an NDA with that investor, if the investor has a relationship with a different brand or company and they provided information to the investor that is the same as yours, that other company has no confidentiality duty to you because you have not signed an NDA with that other party. So this also would fall under exclusion from confidentiality treatment. So these are just some things to keep in mind that are excluded from confidentiality treatment. So the next step is step 6. It's determining the scope of the confidentiality obligations. So 2 main obligations of the receiving party are to keep the information confidential and also to not use the confidential information outside the scope of the agreement. So What that pretty much means is to not use the confidential information outside the scope of agreement means that the investor may not use your confidential information while conducting their own research or making a decision regarding whether to invest in you. So, but they could use the confidential information in regard to making those kind of decisions, but they may not use it for their own gain or in a capacity that's outside the relationship you have with them. So there's also exclusions to the confidentiality obligations. One main one that is, again, this is negotiated for, is if the receiving party is forced to disclose information through a legal process. So that's an exclusion that stands, that if the receiving party is forced to disclose, then that is an exclusion to the confidentiality obligation they have to you, but you can negotiate for that exclusion as the disclosing party by maybe requiring the receiving party to warn you as a disclosing party before the legal proceeding and to cooperate with them. So cooperating with them may include if the disclosing party then files an action with the court to stop that confidential information from having to be shared in the legal process. This would be maybe a separate action taken by you as a disclosing party to ensure that the confidential information is not shared further in that legal process. So you might have the as the receiving party might have an obligation to use the disclosing party to cooperate. So that's something that can be negotiated for, including that kind of stipulation that goes along with the exclusion. So next, we talk about step 7, which is determining the term of the NDA. So there is a main distinction you should be aware of. There is a duration of the NDA, and then there is a duration of the obligations of the NDA. So duration of the NDA will include however long the exchange of confidential information or the flow of confidential information will occur. So the NDA will have a termination clause stating when the NDA will expire. So if you plan to be in discussions with the investor for, say, 2 weeks, the NDA could last those 2 weeks. So any of the information that you'll be providing over those 2 weeks will be protected under the NDA. And so at the expiration of the NDA, there are certain things that could be required, and it will be included in the termination clause. So certain things like could include that at the end of at the expiration of the NDA, the proprietary information shared must be returned or destroyed. So the receiving party would have an obligation to return or destroy the information. Some things here to keep in mind would be some information like physical documents you might be able to return, but there are things like digital files, digital information that you might give to the receiving party that could not obviously be returned. So in those cases, the information would need to be destroyed by the receiving party. So that's some things to keep in mind if you want to require return or destruction or both, depending on the situation. And then there's also with or without certification. So this just means that there may be a clause where the receiving party must provide a certificate to the disclosing party, stating that all the confidential information in their possession was either all returned or destroyed. So that's something to negotiate for. You could either require certification or not, and both parties can decide what they prefer in that situation. And then there's also with or without, which must be given with or without request. So this may include that the disclosing party needs to request the return of or destruction of the information, or they need to request a certification of the return or destruction of the information. So this is again something to be negotiated if if the disclosing party would have the burden of providing a request, or if without request, the receiving party automatically has the obligation to return or destroy their information. And then the next thing we'll talk about is the duration of obligations. So the confidentiality obligations may expire after a definite amount of time, or they may last definitely. So even though the NDA terminates over that set amount of time, the confidentiality obligations that the receiving party bears will continue past the termination of the NDA. So we'll talk more about the term of the NDA. So the term of the NDA is again negotiated for, and the disclosing party may want the terms to last indefinitely, but the receiving party will insist on a defined term. So the disclosing party obviously wants to protect their confidential information as best they can and for as long as they can. So they may want to insist on the term lasting indefinitely, versus the receiving party will want to know exactly at what point their obligations expire, and they'll want to have a defined term for when they have to no longer keep that information confidential. So a definite term, though, may be advantageous to both sides because most information does become useless after a number of years. This is even more the case in certain situations, such as in the tech world, with tech companies, any fast evolving fields where a lot of the confidential information is moving quickly, or a lot of the information is moving quickly, a lot of information is becoming public. And like we said, once the information becomes public, it no longer falls into confidentiality treatment that we just discussed. It would be an exclusion if it's already in the public record and publicly known. So that's something to keep in mind. And then also the last thing is the cost of policing confidentiality obligations may be a burden if there is no defined term. But in practice, many NDAs may have unnecessarily long terms, which do benefit the disclosing parties. So sometimes the receiving party and the disclosing party will think about the cost of policing. So the disclosing party may decide that compared to the minimal burden that they would have to police their NDAs, the benefits of having that indefinite term may outweigh that policing burden for them. So, in this scenario, we kind of went over a situation where you're in a role of the disclosing party and the one contemplating utilizing the NDA. And then now Nick will discuss further if you're on the other side and beyond.
So like Sri just mentioned, so far during this presentation, we've focused predominantly on what to think about if you're the one disclosing information and you want the NDA. But what do you need to think about if you're the one who's asked to sign an NDA as the receiving party? First, don't panic. It's not personal. Companies often use NDAs to protect their information, and it's not a question of how much they trust you, it's simply a part of doing business. You should really consider it a sign that they take your business relationship seriously. When you are asked to sign an NDA, there are a number of things to look out for and a number of key questions to ask. This slide is by no means exhaustive, but it does hit some key items. First, it's important for you to understand the definition of confidential information and what constitutes a breach. It's also important to know how long your obligations last. Like Sri just mentioned, there is a key distinction between the term of the NDA, which could be as short as a single meeting during which confidential information is shared with you, and the term of the obligations, which could mean the 5 years during which you're not allowed to share that information. Then in order to get to the bottom of these things, it's important to ask some key questions like how to identify confidential information, and how can information that wasn't confidential become confidential? And what can you share? For example, I'm currently under an NDA where I'm required to deliver a presentation to a group of people that haven't signed an NDA. And so I need to think very carefully about what information I can share with them while still providing valuable insights. But what if I get it wrong? What happens if you breach an NDA? Or what happens if your NDA is breached? We're going to tackle this question from both of those angles, but first there are a number of considerations that are equally relevant to both parties in that scenario. First, there is the governing law and the venue. Governing law decides which jurisdiction's laws govern any disputes that arise under the NDA, and venue decides where disputes are adjudicated. These two concepts are very similar and they often point in the same direction, but they don't have to. The party with the greater bargaining power often determines the governing law and the venue, but this isn't always the case. And you need to think very carefully about which of these concepts matters more to you under the circumstances. Governing law is ideal where it is most favorable to your circumstances, or is simply more convenient for you to know about. But ultimately, for a random individual or for an early stage startup, it's likely that you care much more about the venue because it determines where you need to be physically located in the event of a lawsuit. It can present a significant burden to have to travel across the country and stay there for however long it takes to solve your matter. Then we should also talk about the available remedies in the event of breach. There are two most common remedies in the event of breach: monetary damages and injunctive relief. Monetary damages are exactly what they sound like. It's an approximate amount of money designed to cover the harm to the disclosing party, including the cost it would take them to resecure the confidentiality of their information and any future lost profits. It's essentially a dollar amount to make it better. Injunctive relief, on the other hand, is a temporary or permanent injunction from the court that prohibits the receiving party from disclosing the confidential information. You can probably already tell that under certain circumstances, it'll make more sense to pursue one remedy versus the other. So for example, if the disclosure was confidential, or excuse me, if it was containable, or it did not yet occur, then an injunction might serve your purposes of protecting your information. But if it's too late for that, if the information is too widespread, then monetary damages might be the best path forward in order to make up for what happened. Another common remedy not listed on this slide is the termination right, which is very relevant in the employment context. Essentially, if an NDA was breached, it might be grounds for termination. So now let's talk about the specific perspectives. What happens if you're the disclosing party and someone breached your NDA? What are your next steps? First, you should determine how the breach occurred and then take measures to address what happened and prevent further breaches. This is really important because it will stem the harm right from the get-go. Then you can worry about identifying the information that was exposed and evaluating the harm to figure out just how much you care about what happened. Fourth, you should review your possible remedies under the NDA. The NDA will very likely list all the available remedies, whether it is monetary damages, an injunction, termination, or anything else. And then you can perform a cost-benefit analysis on pursuing those remedies before making a decision. This step is really critical because while in the event of breach, you likely have certain rights to pursue certain remedies, it ultimately comes down to a business decision on whether you actually do so. And that's because imagine if you're trying to continue to work with someone. If you want to continue to work with someone after they breach an NDA, then it might not be the best idea to fire them or to actively sue them. Just because you have the right to do so doesn't mean it makes sense under your circumstances. But again, this is a purely business matter, not a legal matter. What happens on the other side when you're the receiving party and you breached an NDA? If we can assume that it was accidental, then you should immediately limit your disclosure of the confidential information. Then you can assess the nature of your disclosure and the potential for the disclosed information to become widespread. If there's limited potential for it to become widespread, if it's very containable, then maybe you got lucky. Maybe you can solve the problem on your own. But if there is a potential for the information to become widespread, it could be a good idea to notify the disclosing party immediately of your inadvertent disclosure. That way you can work together in order to stem the harm. At the same time, it'll be important to review the NDA and see what the potential consequences may be so that you can be informed as you navigate this changing environment. Now we're going to shift gears and talk about some of the key regulations to consider. In Massachusetts, NDAs are generally enforceable, but issues may arise where NDAs include a non-compete clause for employees or independent contractors following their termination. To be enforceable in Massachusetts, a non-compete needs to follow certain rules. First, it can only restrict the party for 1 year or less following their termination. Second, it needs to be reasonable in scope based on the geographic region and the specific types of services that the employee provides during their last 2 years of employment. Third, it needs to have the purpose of protecting either trade secrets, confidential information, or employer goodwill. Fourth, it needs to include a garden leave clause, which means that the employer needs to pay the employee at least 50% of their highest salary within the last 2 years of employment for the duration of the non-compete period. Notably, this is a floor, not a ceiling, and the parties are free to negotiate for a higher payout. But even where these rules are met, non-competes will always be unenforceable for certain classes of individuals. Most notably, non-competes will always be unenforceable for undergrad or grad students engaged in short-term employment, namely internships, regardless of whether that employment was paid or unpaid. Similarly, non-competes will always be unenforceable for individuals under the age of 18 or individuals terminated without cause or who were laid off. The takeaway here is that if you want to include a non-compete clause in your NDA, then you should make sure that it's narrowly tailored and in line with all legal requirements for your state. But this can be complicated, and so I want to reiterate something that we said at the very beginning, that it's important for you to speak with an attorney. This presentation is a general overview of NDAs and standard practices, but NDAs are case and client specific. It's very likely that those of you in this Zoom call right now qualify for free legal services from the BU Startup Law Clinic, but even if you don't, it's important to have a lawyer in your corner. With that being said, if there are any questions, we'll take them now.
Hi, I've got a question.
Go ahead.
Right. So I think one of the things in which for startups is, and I'll give you an example in my company, is that we have a few potential contracts with companies, and it is, for us to actually pitch it to a venture capital, we do want to have the names of those companies on, because that is really impactful. And however, as you said, the venture capital in its preliminary stages is not going to sign an NDA. How do you navigate that process?
I think maybe something important to consider would be just how much of the very specific information to your company you're disclosing in those initial conversations. If you're just giving, a general overview, maybe try to limit as much as you can, and then maybe say, if we want to go further and if you want to learn more, then maybe present that NDA option.
And just along those lines, is it okay to have the name of the company that we have a contract with, or does that also, you got to look into the NDA, whether there's a marketing clause along those lines? So even if you don't mention that, what is that contract about and the specific details, are we able to share just the company name and information?
That's something that could be considered confidential under the NDA, but it doesn't necessarily have to be. And so you would need to look at the definition of confidential information in the NDA. Thank you.
I'd like to just jump in here. So, so are you saying, I just want to make sure we understand your question. You're saying a situation where your venture is going to talk to a potential investor and you want to tell your potential investor about either some customers or vendors of yours? Is that what you're saying?
That's right, yes.
Are you talking about customers or vendors?
Customers.
Okay. So there's for everyone on the call, there's kind of multiple different contracts involved here. There's obviously a potential NDA that maybe at some point could be signed by an investor, but as we've been talking about and as you've indicated, that may not be relevant in those early stage discussions. In terms of talking about your customers, yeah, it depends on whatever you signed with them. Maybe you just ask them, maybe say, hey, we're seeking investment and we have some initial conversations, and it would be good for everyone for us to have more money to be, provide better customer service to you. So would you be okay with us mentioning your name in our discussions with investors, just so they know, the caliber of our customers? If they don't, if they're not okay with that, maybe what you could do is at least give some details about who they are in your discussion with the investor without giving away who they are. So we have, 5 customers that are Fortune 500 companies, you know what I mean? Or something like that. We have several customers that are in this field that are this big and are paying us this much or something. That way you don't actually have to give any specific information about them, but it's enough information to show the investor, hey, you've got some real traction.
Great, thank you. I think that was pretty useful. And from our side, we've also asked for letter of intents that they have actually provided. So hopefully that helps us to navigate around that process as well. But it's always, I'm afraid of putting the names in the investor decks, and I will approach them. That's a great suggestion. Thank you.
Great.
Any more questions? You could also feel free to drop in the chat. Austin, I think you raised your hand.
Yes, thanks a lot for everyone's time here. I have 2 questions. So the first is a quick question. So does a startup that hasn't been incorporated have the legal rights to sign an NDA?
I'm sorry, a startup that hasn't what?
Hasn't been incorporated. So like, so it's still like forming legal things. So and it's still in the process of incorporation.
Right. So if you haven't formed fully, you'd be signing it as yourself, as the individual, until the corporation has formed.
Okay, but it's just so if we're signing as using the name of our venture, but it hasn't been formed, so it's not going to be have the legal rights behind that, if I understand it correctly.
Right, but also before you've actually fully incorporated, you could still be a partnership. There's something as common law partnership. So if you have team members, you could still have a partnership, and you could be signing under that partnership until you're fully incorporated. So there's also that.
Okay, great, thank you. And the second question is that so we are actually the co-founders. We have so we are still students, full-time students at Harvard, MIT, and UPenn, and so one of our previous co-founder, he left and then was trying to start a similar a business and also idea. So we had him sign the NDA and non-compete before, but it seems like after this workshop and realized so the graduate student engaged in a short-term employment would not be effective to the non-compete and also the NDA. So maybe that's weird. So I'm just kind of curious, are there anything we can do about it, or it's just not, I guess all the NDA or non-compete will be ineffective since that we're still forming the team, forming the venture, and also based on the requirements. So we are all students. So just trying to figure out the consequence and and what we should do next. Are there any solutions to this? Thank you.
I think just starting off, I don't know if this person was a founder, they may not be qualified, or they may not be in that definition of a part-time employee that might not be eligible for a non-compete. But that's something that you should probably contact an attorney or contact the clinic, and we can actually review those contracts for you. As long as one of your team members currently is an MIT or BU student, we can look at that and see whether or not those things, the NDA or the non-compete, are applicable and enforceable.
Yeah, I don't have a specific answer for you right now. And if you'd like to contact the clinic, then that's might be something that the clinic can look into for you further. But I think that there's an important nuance here in that just because that you happen to be students doesn't necessarily mean that you fit the definition of that regulation that I mentioned in Massachusetts. When you're working in the capacity of a founder, that could be significantly different than what the statute was intended to accomplish.
Okay, great. I see. Thank you so much.
I have a question actually. So
sorry to jump in here. I apologize to cut you off just before we jump on from that prior point. Also, just keep in mind, even if a non-compete isn't enforceable in that situation, and we're not, again, like Nick and Bria said, we're not saying that yet. We need to take a look at it. But even if it isn't enforceable, there are other provisions, hopefully, in that document that might be relevant. So confidentiality itself, if you've got someone who's prevented from disclosing confidential information, that theoretically prevents them from using the information they learned, and so that can kind of keep them from competing potentially. If you had them sign a more robust document that might also have IP ownership provisions in it, then that could also prevent them from working in a similar capacity. So even if there is no non-compete, there might be something in the document that kind of accomplishes similar goals. We'd have to take a look at that document to let you know, though.
Okay, great. Thank you.
I had a quick question. So for mutual NDAs, so I currently have several people working underneath us, and it's my CTO and I that primarily own the company entirely, but we're not at an LLC yet. So we decided to create a mutual NDA that has both his information, my information, and the third partner, meaning the other person that are being involved in it, is that considered a partnership, or is that completely different? And then you need to make a partnership for a separate mutual NDA agreement from it.
So what do you mean by, is that a partnership? So you're saying that you have a mutual NDA with each of your partners, or you have a three-way agreement of some sort?
So for the mutual agreement, there are two people that are in person A category, and then person B, the other recipient, is in the separate part, and we all signed the agreement and we went on with our merry way essentially. Is that considered like a partnership in a sense that my CTO and I are partners, and then the other person associated with it is just signing the mutual NDA, or is that not acceptable?
No, so I think so. There's two different things. So there's something with the NDA agreement, and then there's just a partnership that's kind of just established with you guys, like all three of you working on your company together and building your company and making business decisions together. That itself and building your company is the partnership. And that's already created just based on the work that you all are doing together. And that partnership is recognized before you might form an LLC or a corporation or any of that. That partnership can be recognized. And then there's a separate decision you might have made to sign an NDA with each other to kind of protect the confidential information amongst you all. So the NDA agreement does not kind of solidify or make any partnership on its own. It's the work that you all are doing together and building the company, all that kind of is the partnership, if that makes sense.
Yes, it does. Thank you very much for that.
No problem. Any other questions?
I do have a follow-up actually, sorry. So the competitive aspect to it, so our mutual NDA, so we found one online that was pretty much the most simplistic mutual NDA that's out there. Is there a way to add, like, let's say an amendment or some way to add upon it to make sure that that the people that are working with us are not going to try and create a whole new company that's competitive against us?
Yeah, so there could be different ways to do that. You could try to amend the one you have or create another one that is more holistic, because you, like you said, this is more of a foundational one that you all just found and that you utilized to fill that need at the time. So if you find that you need a more holistic one that includes more provisions that are tailored to you all and more necessary for you all now in the stage of your company, that's something that could be drafted. But yes, definitely, it would definitely require the agreement of everyone. But yes, you could definitely amend it to include different that you might need.
Thank you.
One important thing to mention is that the NDA that you currently have will likely specify whether the parties can amend the existing one. It would almost certainly be by mutual agreement of all the parties anyway. But it might be a matter of simply creating an entirely new NDA versus amending the existing one, depending on what's actually in the contract.
Okay, thank you very much for that.
Any other questions anyone might have? We also just want to let you know that a recording of this presentation will be available on YouTube, and the link to that will be available on our Startup Law Clinic website. So make sure you take a look at that if you ever want to reference back. And as always, you can always go on our website also to fill out an intake form if you ever want to be a client, if you're eligible to be a client with us. If there are no more questions, I think, and then Sam just dropped the link for our website in the chat if anyone needs that. But yeah, if there's no more questions, we'll stick around just in case anyone has any last minute ones, but feel free to go if you have no more questions.